Welcome. My name is Brett Davies. I'm a barrister and solicitor of the High Court of Australia and hold professorships in a number of universities around Australia. And today we're going to build a company. But before we do, let's talk about the three different companies that are available in Australia. There's the proprietary limited company, the PL. Now, 99% of companies are proprietary limited companies, and we're certainly going to build one today. The other one is a limited company, and that's something that you do when you list on the Australian Stock Exchange. You will have a limited company, and they've got really strict rules and audit requirements. So that's the second type of company. The third type of company is an NL, a no liability, and they're generally high speculative mining stocks, which are also listed on the Stock Exchange. But today, we're going to build a proprietary limited company. It's what everyone uses. We all like our proprietary limited companies. Maybe you're building it to be a company to be corporate trustee of a family trust. Maybe you're building the company just so it trades in its own right. So here is a company built to be trustee of a family trust. Very common, probably the most common use of a proprietary limited company. And that takes you through all the rules. Maybe you're building the company to be corporate trustee of a unit trust. And there's the particular type of company that you'd build to be trustee of a unit trust. Or maybe you're going to build a special purpose company. Oh, what's that? That sounds very exotic. A special purpose company is merely, I'm sorry, it's not very exciting, is merely a company you use for your self-managed super fund. So what happens, and here's a special purpose company here that you can build. A special purpose company is a lot of fun because although it can only be used to be trustee of a self-managed super fund, the annual ASIC fees, the Australian Securities Investment, only require you to pay a very small amount of money. So ASIC's very generous if you only use the company as a special purpose company. And this is designed, the constitutions, everything's designed to comply with the SIS legislation, with the superannuation legislation. But today I'm going to go to companies and I'm just going to build a company in its own right. So this is a company which I may well want to trade through in its own right. So let's have a look. What have we got here? A lot of different documents here. We've got over 380 documents, and we're the only law firm in Australia providing legal documents online. When you build a document with us, we're responsible for the document. If you go to a non-law firm website, and all other websites are non-law firm websites, that website buys a document or the template from a law firm, but the law firm's not responsible for it. We're responsible for the document. Now, superannuation trustee company, a special purpose company. A new company, that's what we're going to build. But what about if we've got an old company and it's a little bit out of date? Can we update it? Yes, you can update company constitutions, and this takes you through what you need to do it. And one of the big problems we're finding at the moment for asset protection is that a lot of the older companies require 2 directors. Now, these rules changed many years ago, but the company constitutions, or you may even have articles of association. Oh, that shows you'd be getting pretty old if you've got one of those. That's a bit disrespectful. It's an old company. If you've got a memos and articles of association, you should be desperately updating that, which you can do here. But for asset protection, one of the things we found is that, and here's this poor young lady, if you resign as a director and the company constitution requires 2 directors, there's 2 directors, the wife resigns for asset protection purposes, but the constitution requires 2. There's a strong argument that the trustee in bankruptcy will argue that your resignation as a director did not come through. So there's really big reasons, important reasons to update your company constitution. Division 7A loan agreements. Now, when you build a company with us, you'll always get a Division 7A loan agreement attached to the company constitution. And when you update your company constitution, you get that as well. Division 7A is when the company is lending money to mum and dads or to a trust. Well, that's all well and good. What else have we got? You have a deed of gift. So it might be the case you want to put money into the company as a gift. Unlikely. You have a power of attorney for a company in case the directors are overseas or trapped overseas. You have a Division 7 and a loan agreement. You have a shareholders agreement. That's if you are going to business with other people. And you have a deed of debt forgiveness. Deed of debt forgiveness works where the company owes you money, not where you owe the company money. But today we are going to build a brand new company fully compliant with ASIC. Now, one of the advantages you have dealing with a law firm is when you instruct us, and you've got to be preparing this company now, when you do that, one of my lawyers will actually check the data that you've put in, make sure that the addresses are correct, because the addresses aren't usual, ASIC will reject it. Make sure your business names you have in here are all done. Make sure that you've got the correct structure involved on it. So here is some information, which is great. I'm going to have a look at the checklist. So there is a checklist as to the questions that are going to be asked today. And there's quite a few of them. A company registration takes a lot of information, and we'll go through each of those. So there's something you can print out. Now, if you're an accountant, advisor, or another law firm, you can print that out, get your clients to fill it in. There's also a full sample. So for all documents you build on our website, you always see a full sample. And here is the covering letter. The first thing you're going to get on any of the hundreds of documents that you can build on our website is, thank you for instructing us to prepare whatever document it is. So there's the covering letter, signed by a partner's law firm, and there's the minutes and all the other bits and pieces you need. Company constitution. So that's all good, but let's start building. So the big green button will start building. Now, I am already registered with the website, so to become registered with our law firm's website, we're a law firm, you will need to put your username, password, and just create a registration. Now, I could pick up the data from an old document. So that family discretionary trust, I could pick up that information and spew it and put it forth into the company registration. But in this instance, I'm going to start the company registration from scratch. So the matter reference is, I'm just a mum and dad. Most people building a companies will be accountants, financial planners and lawyers, but let's just say I'm a mum and dad. So I just put my reference will just be company, and I will name the person filling out the form as to who'll be invoiced. The applicant. So let's make it this person here. I agree to this declaration. So this is interesting. We protect you. We are a law firm, therefore we have to act in your best interest. It's important that certain procedures be followed to comply with ASIC's legislation. Now, the largest piece of legislation in Australia is the Tax Act, or the many acts. The second largest piece of legislation is the Corporations Act, and we are now in it, because a company comes out of the Corporations Act. Highly bureaucratic, highly regulated, lots of naughty things happen to you if you make a mistake. So we are there to protect you. So everything we do is designed to make sure that you are protected. So the company information. Now I have going to get a name for my company, and I will make it surely that's available. I don't like proprietary limited. I like that. Actually, I can't stand uppercase, so I'm going to make it this one here. And I don't like full stop, so let's have a look at what else is available. That's what I like. I like proprietary limited. Place of incorporation, it really makes no difference, but I'll go with New South Wales. Do you own a business name? If you do, it'll take you through those rules. So what you might have been doing, you might have owned a business name you've been keeping in reserve and you now want to use it to protect this company name. Exxonly. Did you reserve a company name, which you can do with ASIC? I haven't done either of those things. Now the place of business. Let's make it, I love Little Collins Street in Melbourne. Now, is that the registered address as the principal name? Oh boy, it's getting confusing already, isn't it? We're only into the second question. So have a look at the right-hand side here. These are hints. So at the moment, I'm struggling with what registered address and principal place of business means. And here it is. There's a hint directly on that topic. And there's a training course. Oh, it's a picture of me. How wonderful. So let's have a look here. So the principal place of business is where the business is primarily conducting it, but the registered office may also be your home address, or I generally don't recommend that. It could be your accountant's address, or it could be just your principal place of business or somewhere else. It's where documents will be served or sent to. So it's all here. Look, lots of information. And look, you can telephone us if you need a hand. You can telephone us anytime, or you can do a chat. There's a chat there. We've always got lawyers. They will help you. So the registered address is the same as the principal place address it is. Does the company occupy this address? No, because it's my accountant's address. So I might put in Bollins Accountants. Does the company have an ultimate holding company? No, it doesn't. It's just going to be held by probably a trustee of a family trust, but we'll come back to that later. So does the company have an ultimate holding company? The answer is no. It won't have another company owning the shares. This is not a subsidiary. Now, if I was to produce this company and have 100% of the shares owned by another company, I'd press yes and put in the name of that company, but that's not the case. Is the company only going to be used as trustee of a self-managed super fund? We now know that to be a special purpose company, and no, in this instance it won't be. We'll be using it for many different purposes. But if I didn't know what a special purpose company is, there's a training video. There it is, information on whatever you've got going in your life. There's a hint for it. Now, if you email us or you ring us up and ask questions never been asked before, which does happen occasionally, we'll put a new hint in to deal with that question. So please, by all means, if there's some question you don't understand, just ring up. We'd love to talk to you. We get very few telephone calls because there's so much information here. But if it's something that we can make clearer or is not dealt with, just ring us up. So there's a training course and our telephone number. So I'm pretty happy with all of that. Let's see if the computer's happy with it. Now, can you see the green ticks here? Can you see the green ticks? Legal Consolidated Barristers and Solicitors is an Australian law firm. We are responsible for this document. The company constitution's a deed, and only lawyers can prepare deeds. We're responsible for this document. We therefore have strict logic control, and if you see a green tick, we're happy. If you don't see a green tick, we're not happy. We won't let you lock and build. You will not see the lock and build button unless you see green ticks all the way along. I'm sorry we're draconian, but we carry the risk of this document. So let's have a look, the next. So I've got the company name, I've got the address. It's quite complex, but the hints are very good. Now I've got directors. What's a director? Well, I've got the company, that's like Exxon Proprietary Limited. The directors are the people that look after the company from day to day. And the people that own the company are the shareholders. So directors and shareholders are two different groups of people. They may be the same, but they have different jobs. Director is the guy that looks after the company day to day, and the shareholders are the people that own it. So let's take an extreme example of, say, Rio Tinto, one of the biggest mining companies in the world. The directors of Rio Tinto may not own any shares in the company. The shareholders are 300,000, 400,000, 500,000 people, or companies, or other companies, or trusts. So the directors operate the company from day to day, and the shareholders, at least once a year, will meet to either replace those directors or sack the directors or just approve everything that needs to be approved. So, first director. Let's talk about asset protection for a bit. So I'm just going to do a search of the word asset protection. Legal Consolidated. Let's have a look at asset protection. Now, one of the main purposes of a company, it gives you yet another firewall of protection to you going bankrupt. So this is a really important page on asset protection strategies, which I thoroughly recommend you and your spouse spend 2 or 3 hours going through on everything you need to do. Look, what have we got here? Safe harbours. What's a safe harbour? Spouse can be a safe harbour. A clean skin family trust or a clean skin company, which only owns shares. All these other things on asset protection, wills. It takes you through. It takes you through those things you need to consider, and a company is part of an asset protection strategy. I know what you're saying. You're saying, look, Professor Davies, with respect, if the company goes down, the directors will go down with the company. Yes, I agree with that. And I agree also that the Australian Taxation Office can go directly to a director without even bankrupting or making insolvent the company. I accept that. But it's yet another firewall of protection. So you're trying to put as many restrictions between you and the trustee in bankruptcy. Which now brings us to the question is, who should be the director? So if you're following an asset protection strategy of, in my case, my personal case, a man of straw, I'm high risk, I'm a partner in a law firm, and my wife's a primary school teacher, she's low risk. So I have 3 safe harbours. I've got my wife, I've got Clean Skin Family Trust who just owns shares, and I've got my self-managed super fund. I protect my safe harbours. And I only take on positions of risk for myself because I have no assets in my name. And my wife, I don't have any risk. Don't let any risk happen. Now, let me be very, very blunt. And please cover your ears if you are offended easily. There are 2 types of directors in the world. A director with no assets or an idiot. So there's 2 ways. If you have no assets, you can be a director. If you're a director with assets, then you're an idiot. Okay, you can uncover your ears now for those delicate people. A director is high risk. The Australian Taxation Office can go straight to you if you don't pay your different taxes and things. So you've got to be really careful about whether you're going to be a director or not. I would never let my wife be a director, ever, except for a self-managed super fund, a special purpose company, but we're not building that at the moment. Directors are bad, are really high risk. There's also a good thing in a company called shares. So the director will be me. And I will be the director and director only. So in this instance, will the director be a shareholder? No, I don't know. Because good people, people of substance, hold good things. Shares are good. Directorship bad. Only idiots are directors of companies or they have no assets. So I'm high risk. I've got no assets. I'm a director. And I will not own any shares. Now, if you're building a company as trustee of a family trust, well, it makes not that much difference. You could be a shareholder of that. But we're not doing that. We're building a company. We're just going to trade in its own right. So I've got a tick. I've answered everything correctly. I wish I was that young. And I'm going to press next. No, I won't press next. I'm going to go down to shareholder. I'm going to go directly there. Bit of a naughty thing to do, but I'm in the naughty mood. Do you want to add a shareholder? Well, I have to. Yeah, a company must have an asset. And I'm going to make, in this instance, my wife will be the shareholder. She's from Victoria. Right. Now, what shares are we going to issue to her? What shares? Oh my goodness, it's a lot of shares here. A class, B class, founder class. Oh my goodness gracious me. Now, there's a hint on that. But in this case, I'm not coming into anything complex here. It's just going to be a business that we're going to operate out of. I'm just going to issue her with a number of shares. I'm going to issue 10 shares at a dollar each. $10. I could issue, let's say if you're going to list this on the stock exchange in 4 or 5 years' time, well, maybe I'll give myself, I don't know how many tens of millions, but that'll be at 0.001 cent each. Are the shares beneficially held? What does that mean? Well, this is the question of equity versus legal ownership. This is a question of trust law. If my wife holds these shares for herself, then she holds them beneficially. But if she was to hold the shares for our 14-year-old son, then she would press no and type in our son's full name. If we were building this to be, let's say that the company was to hold shares, or the shares are going to be held by a family trust, she'd press yes and then type in the name press no and type in the name of the family trust. Because it's a good idea to have, and the ACN of that family trust. It's not a bad idea to have the shares held by a family trust. So at this point, she is the trustee of a family trust and she's holding the shares for her, or she's just decided to hold the shares in trust for that family trust. Not a bad way of going, and your accountant may well recommend that strategy. Well, this is good. We're going well now. We don't put the dollar sign in. Okay, well, I've done all that. I've done everything I need to do. Does the director hold the shares beneficially? Press yes. Does the shareholder? Selling shares. Now, again, don't spend too much time on this if it's just mum and dad owning the company or controlling the company. This is more if you're going to business with 3 or 4 of your mates. So I would best to leave the defaults in. But we'll go through it nonetheless. Offer shares to remaining shareholders before selling to non-shareholders. Preemptive rights. Oh, what's happening there? What happens is the big shareholder has got someone that wants to buy the shares. So they just want to buy your interest, which is say 60%. And the poor old 40% people want to have the rights to also come along on that adventure. What another situation is where the big 60% guy wants to sell the company, but sell his shares in the company, but the person that is wanting to buy it wants to buy 100% of the company. Well, this forces it. This is called tag along or come along rights. So the 40% people have to also sell for the same basis of the majority shareholder. And there's a percentage of 75% in that instance. I'd leave this all as they are. Come along rights on qualifying transfers, allow minority shareholders to join a majority shareholder sale, tag along rights, demand transfer on takeover. These are important issues, but only if you've got another non-family member co-owning the company with you. In this case, it's just mum owning it for the family trust. I'm not going to press this here. I'm going to press next, and I'm looking pretty good. I've got green ticks everywhere. The reference is just company registration. Happy with that. Select this box if you want your business logo on the documents. Well, if you're an accounting house, financial advisor, or lawyer, you'd probably want to do that because it looks good, and people for years to come, your client will know that you were involved in the company. But I stress that the responsibility of this company rests solely with legal consolidated barristers and solicitors, even though your logo may go on. Check the box to remove legal consolidated's logo from the deed. Only do that if you're a lawyer and you're white badging our legal documents. If you're a lawyer, do what you want to do. If you're not a lawyer, don't tick that box. You want us to be responsible for the document. We still are, but you want people to know that we prepared it and we're responsible for the document. Select the box if you also print, bind and post. That's quite common for companies. Select the box and one of our lawyers telephones you to review and explain the legal documents. I don't think you'll need that in this case. If it's a complex transaction, maybe, but not in this case. I'm happy. I'm going to go to next. Now, why don't I see lock and build? I can't see lock and build. You can't see lock and build because you haven't finished. Press next. Lock and build. I've got lock and build. I'm very excited. So that means, as far as our law firm's concerned, we're happy. But you now need to go through the summary page and just check the spelling. This person's middle name is ASDF. Is that correct? If not, go back and change it. The addresses look fine. That looks good to me. I'm happy with that. So I'm going to lock and build. Now, once I press lock and build, it's locked. I cannot change it. And here come the credit card details. I will enter my credit card details. So the documents are now being created and it's available to me to have a look at. Now, we are a teaching law firm, and one of the students just asked the question about what if you have a falling out with a family member? Well, that doesn't matter because it's just you and your wife that own just your wife that owns the shares. And if you have a falling out with your wife, your mistress, or your gay partner, and you can have all three in Australia, bigamy is alive and well, then that dispute goes to the family court. And the family court doesn't care that you've got assets in a family trust. It doesn't care you've got assets in a company. It treats it like it's owned by everyone. So there's a bucket here. So here's my water bottle. So what happens is they tip into the water bottle your family trust assets, swirl it around. You've got 3 or 4 companies. They tip that into the bucket, and all the assets in your wife's name, Aston Martin, gets tipped in there, and all your assets get tipped in there. So it's all in here. And what they now do, so there's family trust assets. What they now do, this is the family court, shake it around. They don't care you're in a company. They don't care you're in a family trust. It's all just part of the family asset. So there it is there. It's all mixed up. And the family court will then decide how that's distributed. So maybe you'll get this, you will get the sewing machine. Maybe the wife will get your Ferrari. Who knows? So don't worry about the issues between a husband and wife. The family court will just cut the cake as they jolly well see fit. Now, I've done a company registration. Wow. And there's a PDF. It's locked. Oh, Professor Davies, I don't want it locked. I want to be able to change it. You can't change it. We are responsible for the document. If you want to change it, ring us up. We'll have a talk about that. You can't change the document. It's our document. We're responsible for it. So let's have a look at what you've now built. Whoa! I said the first thing you get was a covering letter, and there it is on our law firm's letterhead. We're responsible for this document. Thank you for instructing us to incorporate your company. You might have been a financial advisor that put the data in. We, the law firm, are still responsible for this document and for every document that comes out of this and the incorporation of the company. You might have been an accountant that put the data in. Our law firm is responsible for that document and everything that comes out of it. So how to print the document. Okay, download the PDF. This is good. Something about company names. Tax file numbers. Now, your accountant will generally deal with tax file numbers and applying for Australian business numbers and registering for GST. They're all free on the Australian Taxation Office. And there's some hints and help there. But We are tax lawyers. We are not accountants. I have 7 degrees. 4 of them are in tax. I'm a professor at a number of universities lecturing in tax. I've never done my own tax return. I can't do my own tax return. Give me a dispute with the ATO in the federal court. I'm up to trot on that, but I've never done my own tax return. This law firm is a tax law firm. We're not accountants. You'll need to get tax file number and ABNs, all that sort of stuff from your accountant. So, now this is interesting. And this is, remember I spoke about protecting you, the client, because that's our job. Our job is to protect you. That's a law firm's job. Unfortunately, when you go to a non-law firm website, and all websites are non-law firm owned, maybe partly owned, but you are getting a resold template. Here, you are dealing directly with the law firm. What happens is that the company's incorporated immediately, and the company's not incorporated yet. You must make sure that you've signed your consent to be a director before the company's incorporated. I'm going to say that again, because it's not well understood, and I'm here to protect you. You should, under Australian law, sign as a director to consent to be a director of a company before it's incorporated. Unfortunately, when you go onto a non-law firm website, they'll incorporate it straight away. So there's no way on God's earth you could argue that the director had consented, and you're setting yourself up to damage the client and fail. Here's your consent. Sign it quickly, because we're about to incorporate this company. So the lawyers now, the back end. Yep, they're in there. They're incorporating the company. So sign that consent. There's only one director, so only one consent. And here's the shareholder. That was your beautiful wife. And she's getting how many? Jeez, she's getting 10 million, is that 100 million shares at 0.0001 cent. This sounds like they're setting this company up to list on the Australian Stock Exchange in a few years' time. How exotic. Makes no real difference what you put there. Shareholder is beneficial owner of the shares below. So the beneficial owner is the family trust. And it looks like if we need to telephone you, we will telephone that person. So it might be the accountant. That's it. That's the document. Now what's going to happen now is the lawyers will now incorporate the company, or if they can't get the company name, they will telephone that person and say, look, we've got an issue with the company name, or the address is not being the address is not known to ASIC, and they will work through it. So you've got lawyers to protect you to make sure this document works. So the lawyers at Legal Consolidated have incorporated the company and now get a second email. And this is contained in the company constitution and all the rules attached to it. These are very carefully drafted company constitutions to protect you. It goes on for many, many pages. You're not required to print that off. You can leave it in electronic form. Let's have a look at it's the end of the company constitution. The adoption of the company constitution. In this case, I've picked another our sample document. So in this case, there's 2 shareholders, John and Alice, and they will accept the constitution. And we'll see what share classes they've got. And this is a proxy form. So what's this? Well, when the shareholders vote at the end of the year, they may not necessarily be in Australia, in which case they might want a proxy, or they may not want to turn up, or they may be getting a bit old and fragile, or whatever reason. So they may sign a proxy form. There you've got a proxy form. That's useful. Then you've got resolutions of directors. So This is a circulating resolution. This deals with the post-coronavirus environment where we may not want to all meet up together for whatever reason. So you can do things by circular resolution. You need a secretary. So in this company constitution, the first director is always the company secretary and the office holder. So these are the responsibility of the director is great, but it's increased because the secretary also has additional obligations dealing with the Australian Taxation Office and ASICs, and the public officer and secretary have additional obligations, and that is the job of the first appointed director. There's a registered office, principal place of business, and that's now accepted by the company officers. Wow, more records of resolutions. So this is from the directors. Now, what's the difference between a director and a shareholder again? The director has the day-to-day conduct of the business and carries all the risk and makes sure your directors have no assets in their name. Shareholders are good things to have, so you put that in the person of straw, a person of substance. That's nice, very nice. Register of members, so that will just be changed from time to time. So in this instance, the only shareholders, one ordinary shareholder, $1 under this sample. Register of members. Options. There are no options, but an option is a right to buy the share in the future, and the company can issue and allot those. This company constitution is a work of art. It allows you to do incredible things with it, and one of them is to be able to issue options. I don't think we're going to do that in this case. It's just a mum and dad business we're going to operate out of this company. Debenture holders. A debenture holder is someone, so the bank will come to you and say, look, you've got $2 million of value in of trading stock in the company. We'll lend you $1 million, but we want a debenture or a fixed and floating charge over the assets of the company. This is your debenture holder. Public officer. So here it is. If you think, there's no risk being a director, well, here we are. So you're a director and you're also the public officer. So you let the Commissioner of Tax, you let the Australian Taxation Office know that this poor guy here, George Smith, as well as being a director, is also the public officer. So when the Australian Taxation Office wants to knock on the door, they're going to ask for John Smith. So public officer, and John Smith's also wearing two hats. He's a director and he's the public officer for ATO, and Alice is just a mere director. Now, if you're ever going to move this to a special purpose company, it's all ready to do so, but we won't be needing that. Share certificates, just providing evidence that this lucky person owns the shares in the company. So that's John George Smith has that share. Share certificates aren't that popular these days, but we still prepare them anyway. It gives people peace of mind, and that's very important. And there's your certificate of incorporation. We're there. So ASIC this is what's been emailed to you. This is the rubber stamp from ASIC to say this company's been formed and it's now registered. You have a company. You've created a new child, a new mouth to feed. So you can have trusts, you can have companies. In this case, you've got a private limited company. Now, when you are building the company, telephone us anytime. We're happy to give you a hand building it. But you really want to have a bit of fun reading the hints and training videos. It will really educate you into how companies operate. As an academic, I am very keen that people understand what they're doing. I don't like giving you a family trust, you've no idea how it operates. I don't want you to form a company only to find that you don't really understand it. I don't want you to embark upon asset protection strategies unless you know the philosophy and everything behind it. And that's what our website stands for. That's what Legal Consolidated stands for. We want to empower you, the accountant, the financial advisor, the lawyer, the mum and dad, to understand exactly why you're building this document and what it's good for and its purposes. So enjoy this beautiful website and the training that you get from it, and enjoy the wonderful high quality documents this law firm produces through the website.